Talking about vaccines, I'd now like to turn it over to Kristen Guinn, shareholder with Smith, Haughey, Rice, and Roegge, who will give an overview of legal considerations that employers need to think about when it comes to liability and confidentiality. Kristen?
Thank you, Andy. As Andy said, my name is Kristen Guinn, and I'm a shareholder at the law firm of Smith, Haughey, Rice, and Roegge here in Grand Rapids. I'm here to speak with you today about some issues facing employers as we navigate the administration of the COVID-19 vaccine. I will talk with you today about whether an employer may mandate or incentivize the vaccine, what legal exposure employers face regarding COVID-19 compliance, and maintenance of necessary levels of confidentiality. Many of my clients, colleagues, and friends have asked me if an employer can mandate the COVID-19 vaccine. It's a common question. The short answer, neither federal law nor Michigan law mandate vaccines for any group of people. There's nothing in federal or Michigan law that requires an employer to mandate that its employees obtain the vaccine. Interestingly enough, California is now the first state to address mandatory vaccinations, whereby it is expressly permitting employers to do so as long as it complies with the parameters I'll be discussing with you today. In Michigan, even though the law does not expressly address it, some employers may wish to explore mandatory vaccination programs. To date, the primary authority on this is the December 16, 2020 guidance by the Equal Employment Opportunity Commission, or the EEOC. This guidance provides that an employer can mandate vaccines for their employees as long as they comply with the provisions of the Americans with Disabilities Act, or the ADA, and an employee's religious freedoms as guaranteed by Title VII of the Civil Rights Act. Under the ADA, an employer who is mandating the vaccine must evaluate who cannot receive a vaccine due to a medical or disability-related condition. Now, if the answer is yes, the employer must attempt to make reasonable accommodations, and we know that phrase, such as remote working, absent undue hardship, of course, before excluding the employee from the workplace. Further, the EEOC guidance also clarified that the administration of a COVID-19 vaccine is not a medical examination under the ADA, which, as some of you may know, can be prohibited conduct depending on the circumstances. Now, under Title VII, an employee who cannot receive the vaccine due to a sincerely held religious belief, practice, or observance must be reasonably accommodated unless it would impose an undue hardship on the employer. Now, employers should also confirm that no genetic information is being acquired through pre-screening questions or while obtaining proof of vaccination for their mandated vaccine. Further, one more thing to consider is whether an pregnant employee cannot take a vaccine due to a pregnancy-related medical condition, which may also entitle some reasonable accommodation. Now, to add more interest to it, one consideration is whether the vaccines that have been authorized for use under the Emergency Use Authorization, or the EUA, can be mandated by employers since they have not received full FDA approval. The statutory authority under which EUA vaccines are authorized requires recipients to be informed of such vaccines, the choice to accept or refuse the administration of the product, and the consequences of refusal. This has been read by some legal and medical scholars to mean that mandatory programs for EUA vaccines are not allowable. However, others, pointing to the language of the statute and the EEOC guidance, among other things, have argued that EUA vaccines can be mandatorily implemented when the EEOC guidance is followed. Needless to say, the area of mandatory vaccinations is evolving and requires an employer to maintain a clear policy based on the current regulations and guidance. Alternatively, employers can also choose to incentivize vaccines through incentives such as additional compensation, bonuses, vacation, or other PTO. Instead of a mandatory vaccination policy, an employer may wish to provide some of those additional incentives that I mentioned. An employer should be mindful of the requirements of ERISA, group health plans, and HIPAA wellness program regulations when considering incentives. They should provide alternative ways to earn those incentives by employees who do not want to receive a vaccine. For example, maybe attending a training or continuing education program. Employers want to follow certain best practices, such as, again, creating and implementing a written policy, tailoring a vaccine program, creating a process for providing reasonable accommodations to employees, and being mindful of state and federal law regarding employee leave and layoffs. As you can see, there are many considerations to think about whether mandating or incentivizing the vaccine. Now, Michigan has passed some laws that provide employers immunity from liability for COVID-19 related claims, as long as they are in compliance with COVID-19 related government directives. Now, whether an employer is mandating or incentivizing, there's always this question about legal exposure in the face of COVID-19. The COVID-19 Response and Reopening Liability Assurance Act in Michigan, that's a mouthful, provides immunity from liability from COVID-19 tort claims against employers. It applies to those employers who act in compliance with all COVID-19 related government directives, including federal and state law, executive orders, and agency orders. Generally speaking, small deviation from strict compliance is not likely to remove the immunity. But workers' compensation actions are not affected, and an employer can still face claims by a state or local prosecutor or agency. What this means is that an employer may have immunity under this act from claims related to exposure or potential exposure to COVID-19, or to conduct intended to reduce the transmission of COVID-19 in the workplace. The most important component to this protection is the employer must be complying with all of the government directives related to COVID-19. Now, the Michigan Occupational Safety and Health Act, or MIOSHA, was amended to provide immunity from liability for an employee's exposure to COVID-19. Again, the employer must be operated in compliance with all of the COVID-19 related government directives under the law, executive orders, and agency orders. And again, a small deviation from strict compliance usually will not remove that immunity. Additionally, there's a Michigan statutory provision that protects employees from retaliation, discharge, or discipline if the employee is in compliance with COVID-19 directives contained in the law, or if the employee reports health violations. An example would be if an employee tests positive for COVID-19, displays its principal symptoms, or comes in close contact with a confirmed or suspected case of COVID-19, that employee should not report to work. Now, as a result, employers cannot discharge, discipline, or retaliate against that employee. It is worth pointing out, however, that these protections to the employee do not apply if they have the principal symptoms of COVID-19 and fail to make reasonable efforts to schedule a test within 3 days after the employer has asked the employee to do so. All of these provisions I've spoken about are retroactive to claims that accrue after March 1st, 2020. Now, employers could face several COVID-19 related claims, including workplace safety claims, such as a failure to protect or follow proper safety protocols, leading to COVID-19 transmission. Such claims will have to contend with standard of care and causation issues. Now, what do I mean by that, lawyer? It is in the COVID context, it would be challenging for an employee to prove that he or she contracted the virus while at work, rather than through some other means within the community. An employer may also face workers' compensation claims for injuries sustained during the course and scope of their employment. Again, here, it will be difficult for the employee to prove the exposure occurred at the workplace. Other claims could be related to OSHA and MIOSHA citations for violating the general duty to provide a workplace free from recognized hazards. MIOSHA has promulgated regulations in response to this pandemic, and we can certainly see that many of our local employers are maintaining full compliance. MIOSHA has specifically stated that employers must prepare a written COVID-19 preparedness and response plan, implement basic infection prevention measures, conduct daily screenings of employees and contractors, usually through a questionnaire, notify the local health department of any employee, visitor, or customer's known case of COVID-19, designate COVID-19 safety coordinators, post signage encouraging social distancing and hygiene, provide face covering to employees at no cost, and provide current and updated training about coronavirus and COVID-19 to employees. Also, as previously mentioned, discrimination, retaliation, and harassment claims based on COVID-19 status or decisions made during furlough or layoffs are also possible. In this context, employers should remain vigilant when it comes to reduction in force decisions, where such reduction may eliminate employees with protected characteristics, such as age, race, national origin, gender, and other protected categories. Employers should audit their reductions to confirm that unintended discrimination has not occurred. An employer may also see disability-related failure to accommodate claims based on federal and state law. In the era of COVID-19, a duty to accommodate may arise when an employee requests leave or another accommodation because of an existing disability that makes him or her particularly vulnerable to COVID-19. It may also be the case that the disability is exacerbated by the threat of the virus or the safety precautions taken. The employer should engage in an interactive dialogue with the employee and possibly the employee's medical providers to determine if reasonable accommodations can be ascertained. Typical accommodations in this area are often telework, additional physical barriers from other workers, or even limited leave based on the circumstances. Finally, claims may arise due to failure to protect employee privacy and confidentiality, which I will get into further in a moment, or denial or miscalculation of sick or family leave, among other types of claims. Lastly, it is important for the employer to continue to maintain the appropriate level of confidentiality, whether the company policy is to mandate or incentivize the vaccine or otherwise. Employee medical information is protected by several laws, including the ADA, HIPAA, and the FMLA, to name a few. The ADA requires the medical information be kept confidential unless required to be disclosed to supervisors or managers to provide necessary accommodation, and that this information must be kept separate from other personnel files. Employers subject to HIPAA, such as those who may be watching today, must also abide by privacy protection obligations and keep the protected health information confidential. COVID-19 testing results must be treated like confidential medical information, and the same safeguards must be applied. Employers can notify those who have had close contact, i.e. exposure, with the employee without identifying the employee's name or any other information that must identify them. The EEOC guidance I've mentioned today makes clear that managers may report exposures to COVID-19 to appropriate personnel in the organization in order to comply with public health authority guidance, such as contact tracing. It is important to remember that even if asked by an employee, the employer cannot confirm or reveal the infected employee's identity. Employers should also be cognizant of OSHA record-keeping obligations. COVID-19 cases must be recorded if it's a confirmed case of COVID-19, is work-related, and meets certain criteria for general recording as outlined by OSHA. The EEOC guidance has stated that asking or requiring an employee to provide information on whether or not the employee was vaccinated is not a disability-related inquiry under the ADA. Now, to be clear, asking an employee why he or she did not receive a vaccination may elicit information about a disability and could be subject to ADA scrutiny. Employers should make certain to warn employees not to provide medical information when providing proof of vaccinations. And, like other health records, employers must treat vaccination records as medical information and keep the vaccination records in separate, confidential files similar to other employee medical information. The bottom line, as we counsel employers on navigating COVID-19 related issues, is to make a policy and follow the policy. Consultation with your friendly attorney can be very beneficial in this instance, not only to make sure your policies are in line with the current law, regulations, and guidance, but also to make sure that your employee handbook is consistent with those updated policies. Although different than what an employer may have faced in the past, these COVID-19 challenges are manageable and can be properly addressed through a little focused preparation. It's been a pleasure sharing this information with you. In the event you need additional information or clarification, I welcome you to reach out to me. Thank you.
Thank you, Kristen. Great information. Local employers have a ton to consider when we're talking about coming back to the office, vaccination. Truly appreciate your insight. One incentive that we did see out there, maybe for folks getting the vaccination, is that Krispy Kreme is going to give you a free donut every day you prove to them that you had your vaccination. So maybe that'll motivate some folks to get their shots.